One court, 9 states, 65 million Americans, and a 132-year streak so mathematically impossible that no statistician would call it coincidence. They would call it a fixed result. The Second Amendment Foundation just filed a 47-page legal document so explosive, so precise, so devastating in its documented evidence that legal analysts are calling it the most aggressive brief ever filed against a sitting federal court in American history. The Ninth Circuit Court of Appeals has reversed 100% of Second Amendment victories at the en banc level. Not 90%, not 95%, 100%. In 132 years, exactly one gun rights win survived, and it only survived because California forgot to file their appeal paperwork. This is not justice. This is coordinated constitutional warfare. I'm Sarah from GunGuidePro, 10 years in the firearms industry, and today that warfare is being exposed with documented evidence that demands a reckoning. Before we go any further, subscribe to GunGuidePro right now and turn on every single notification. We are a new channel building something genuinely important here. Real-time legal coverage for the 65 million Americans the Ninth Circuit has been systematically failing. This case is developing rapidly, and when the court responds or the Supreme Court intervenes, you need to know within minutes. Every subscriber tells us this content matters and gives us the motivation to keep delivering this level of analysis. 2 seconds, completely free. Hit that subscribe button. Hit that bell. Let's get into the evidence that changes everything. Let me start with the statistics, because this is what proves systematic bias beyond any reasonable doubt. The Ninth Circuit takes less than 2% of all cases for en banc review each year. En banc means the full panel of judges rehears a case instead of the standard 3-judge panel. It is supposed to be rare, reserved for exceptional cases involving major legal questions or direct conflicts with Supreme Court precedent. But when it comes to Second Amendment victories, they take every single one. 100% of the time. Every gun rights win at the 3-judge panel level gets pulled back in front of the full court. And every single time, that full court reverses the victory. In 132 years, 9 states, 65 million Americans, exactly one Second Amendment win survived. And that was by accident, because California's Attorney General forgot to file their appeal paperwork on time. Think about the mathematical impossibility of that pattern. Flip a coin 132 times. The odds of it landing on the same side every single time except once are astronomically small. No statistician would call that random variation. They would call it a fixed result. And here is the other side of that equation that makes it even more damning. When gun control laws are upheld by a 3-judge panel, how often does the Ninth Circuit grant en banc review to reconsider? 0? Never. Not once. When gun control wins, the 3 judges apparently got it right. No need for the full court. When gun rights win, suddenly it is an exceptional case requiring all 29 judges. The en banc process has been weaponized. It exists in Second Amendment cases for one purpose only: to destroy victories that gun owners legitimately earned in court. Drop your state in the comments right now. Are you in one of the 9 states under Ninth Circuit jurisdiction? California, Oregon, Washington, Arizona, Nevada, Idaho, Montana, Alaska, or Hawaii? I personally read and respond to every single comment on this channel. Here is the layer that does not get enough attention, and the brief dedicates significant space to exposing it. This is not just legal warfare. This is financial warfare designed to bankrupt the organizations fighting for your rights. Nonprofit gun rights organizations, Second Amendment Foundation, Firearms Policy Coalition, California Rifle and Pistol Association operate on limited budgets built from individual donations. They are not funded by taxpayers. State governments like California have unlimited taxpayer funds to defend their laws in court. The cost to them is irrelevant. They can fight forever. A standard federal appeals case costs between $50,000 and $200,000 in legal fees. When on-bank review is forced, that cost triples. You are now looking at $150,000 to $600,000 for a single case. California alone spent over $15 million last year defending unconstitutional gun laws. The Second Amendment Foundation operates on under $5 million total annual budget across all cases nationwide. Here is the trap. Gun rights groups win at the district court, win again at the three-judge panel. California petitions for en banc. The Ninth Circuit grants it immediately. And now the organization must fight the entire case again from the beginning, with triple the costs on a timeline stretching years, and a 100% historical rate of losing. They can appeal to the Supreme Court, but SCOTUS accepts roughly 1% of petitions, and that process costs another $200,000 or more. Either path drains resources that could be fighting 5 other cases. The brief calls this exactly what it is: systematic abuse of procedural tools to achieve political ends through financial attrition. Which politician in your state do you think has been most aggressive about using the Ninth Circuit's systematic bias to block gun rights challenges? Name them in the comments right now. I want to see who this community holds accountable. Now let me tell you about the specific case that finally pushed the Second Amendment Foundation to file this unprecedented 47-page constitutional indictment. Woolford versus Lopez, a challenge to Hawaii's gun registration scheme. Here is how Hawaii's system works. You pass a federal background check through the FBI's NICS system, examining your complete criminal history, mental health records, domestic violence records. You legally purchase a firearm from a federally licensed dealer. The federal government has determined you are not a prohibited person, but Hawaii says not so fast. You must register that firearm with the state and physically bring it to a police station for inspection before you can legally possess it in your own home. A 3-judge Ninth Circuit panel struck this down unanimously. All 3 judges, including judges appointed by Democratic presidents, agreed that Hawaii's system was historically unprecedented and facially unconstitutional. Hawaii's attorneys could not cite a single founding-era law requiring citizens to bring firearms to government officials for inspection. Not one. The historical record was empty. So what did Hawaii do? They petitioned for en banc review, and the Ninth Circuit accepted that petition within 48 hours. Not weeks, not months. 48 hours from petition to acceptance. The average time for en banc acceptance in other constitutional cases is approximately 8 months. 48 hours. That is the smoking gun. That is when the Second Amendment Foundation decided this needed to be documented and exposed at the highest level possible. Have you ever heard of any federal court granting en banc review in 48 hours in a case the state just lost? Type "never heard of it" or "this is normal" in the comments. I want to see how informed this audience is about how extraordinary that timeline actually is. Here is where the brief moves from statistical argument into documented evidence. And this is the part that has the legal community paying the closest attention. The brief documents coordination between Ninth Circuit judges and anti-gun state governments through court records, procedural timelines, and judicial statements. First, the timeline data. En banc petitions from gun control states in Second Amendment cases average 23 days from petition to acceptance at the Ninth Circuit. In other constitutional areas, 8 months. That gap is not random variation. That is a documented, systematic pattern of prioritization. Second, public judicial statements. The brief quotes a Ninth Circuit judge who wrote on the record that the court would interpret Bruin as narrowly as possible to minimize its impact on gun control laws. That is a federal judge publicly admitting they intend to undermine binding Supreme Court precedents. That is not judicial independence. That is judicial rebellion. Third, the invented legal standards. In First Amendment cases, Fourth Amendment cases, equal protection cases, the Ninth Circuit applies normal constitutional analysis. In Second Amendment cases, the brief documents that the court has created tests and frameworks that exist nowhere else in constitutional law and are specifically engineered to make gun rights claims impossible to win. Fourth, and this is the smoking gun, the brief formally requests disclosure of all communications between Ninth Circuit judges and state attorneys' general offices, emails, meeting records, any documented contact. Because the pattern is so consistent and so mathematically improbable that the brief argues the only coherent explanation is active, ongoing coordination. And confirming all of this, the Supreme Court has reversed the Ninth Circuit on Second Amendment issues at a 90% rate. 9 out of 10 times the Supreme Court reviews a Ninth Circuit gun ruling, they overturn it. That is not a normal error rate. That is a court in systematic defiance of constitutional law. What is your honest prediction? Do you believe there is active coordination between Ninth Circuit judges and anti-gun state governments? Type coordinated or independent in the comments. I want the real read from this audience. Here is where this brief becomes genuinely historic in what it is asking for. The Second Amendment Foundation is not asking the Ninth Circuit to reconsider its position. They have moved past that entirely. They are building the legal architecture for Supreme Court supervisory intervention, a mechanism invoked exactly twice in American history. The first instance was during the Civil Rights era. Southern federal courts were systematically refusing to enforce desegregation. They ignored Supreme Court precedent. They coordinated with state governments. The Supreme Court stepped in, not just to rule on individual cases, but to exercise supervisory authority over those courts, forcing structural compliance with constitutional law. The second instance involved systematic violations of criminal procedure protections, where lower courts were rubber stamping police misconduct. Again, Supreme Court supervisory authority. The brief is arguing that what the Ninth Circuit has done to the Second Amendment over 132 years is legally and structurally identical to what those courts did during the Civil Rights era. The pattern is documented. The defiance of Supreme Court precedent is documented. The coordination with state governments is alleged with evidence. The statistical impossibility of the outcomes is demonstrated mathematically. 3 specific demands. First, the Ninth Circuit must withdraw en banc review and reinstate the 3-judge panel decision. Second, if they refuse, the brief establishes full grounds for emergency Supreme Court intervention, including a direct request that SCOTUS stay the en banc proceedings. Third, a congressional investigation, including subpoenas for judge-government communications and sworn testimony before House and Senate Judiciary Committees. Should the Supreme Court exercise supervisory authority over the Ninth Circuit and force constitutional compliance on Second Amendment cases? Type SCOTUS intervene or let it play out in the comments. I want every opinion here. Here is what happens next, and why the answer matters for every gun owner across the entire 9-state Ninth Circuit jurisdiction. If the Ninth Circuit withdraws en banc review and reinstates the panel ruling, that is an admission. It proves the en banc process was being abused as a political tool, and it opens the door for every reversed gun rights case in recent years to be reconsidered under that admission of bias. If the Ninth Circuit refuses and proceeds with en banc review, the legal groundwork for emergency Supreme Court intervention is already fully laid. SCOTUS could stay the en banc proceedings, could take the case directly, could issue a supervisory order, could refer individual judges for investigation. Congressional oversight also activates independently. When a federal court is accused of systematic constitutional violations backed by 132 years of documented statistical evidence, the House and Senate Judiciary Committees have both the authority and the political motivation to act. subpoenas for communications, financial disclosure reviews, public hearings with judges testifying under oath. All of it is now on the table. And here is what this means for every gun owner across those 9 states. If this brief succeeds, every gun control law in the Ninth Circuit jurisdiction becomes legally vulnerable to challenge. Magazine bans in California, assault weapon bans in Hawaii, carry restrictions in Washington. All of them upheld by a court now under formal documented challenge for 132 years of systematic bias. Attorneys will refile cases, demand new review before impartial courts. The entire legal landscape of the Western United States could shift. Here is the absolute bottom line. One gun rights win in 132 years, and bank review granted in 48 hours for anti-gun states. Public statements by judges admitting they will resist Supreme Court precedent. A 90% reversal rate when cases reach the Supreme Court. Mathematical impossibility of random outcomes. This is the documented record of the Ninth Circuit on Second Amendment cases. And the Second Amendment Foundation just put all of it into a 47-page constitutional indictment that demands a reckoning. The Ninth Circuit faces a choice: admit bias and change course, or face the most serious judicial accountability challenge in modern American history. Here is what you do right now. First, subscribe to GunGuidePro and hit that notification bell immediately. We are a new channel, and every single subscriber gives us the motivation and resources to keep covering this case at this level. When the Ninth Circuit responds, when SCOTUS moves, when Congress acts, you will know within minutes. Second, smash that like button and share this video with every gun owner you know in California, Oregon, Washington, Arizona, Nevada, Idaho, Montana, Alaska, and Hawaii. All 65 million of them deserve to know what this brief just exposed. Third, answer all 3 questions in the comments right now. What state are you watching from? Which politician in your state do you hold most responsible for using the Ninth Circuit's systematic bias to block gun rights? And what is your favorite Second Amendment ruling of your lifetime? Heller, McDonald, Bruen, or something more recent? I personally read and respond to every single comment on this channel. GunGuidePro is just getting started. This story is not over. It is just beginning. Stay informed, stay armed, stay free. I'm Sarah from GunGuidePro. See you in the next one when the Ninth Circuit responds to this constitutional indictment.